Hello and welcome to the Herrington Carmichael Employment Law Update for October 2017. I'm Alistair MacArthur, I'm the head of the employment team with Herrington Carmichael, and this month I've got 3 updates for you. Let's start with the latest set of Aircast guidance in relation to the support employers need to provide to parents with premature or sick babies. If an employee has a premature or sick baby, it can be a really unsettling time for them. And employers need to be live to this and need to look at the new Aircast guidance which has been publicised. This talks about making sure employees are aware of their statutory entitlements in terms of paternity leave or parental leave, how communication with employees in these circumstances is dealt with, and allowing flexible working for employees in those circumstances. If you are dealing with an employee who has a sick child, or a sick baby, forgive me, what you need to do is you need to go and look at that Aircast guidance, study it very carefully and make sure you're complying with it. Next, the case of Barbulescu and Romania. This is a case which we've talked about previously, and it relates to the accessing of an employee's private messages on his Yahoo account in the workplace. The original decision of the European Court of Human Rights held that an employer had the right to go and access private messages of an employee which were taking place in the workplace. That's now been reversed, and what the decision says is that effectively an employee still has a right to a private or family life while they're in the workplace, and the employers need to observe that. A distinction needs to be drawn between what is on a private email account or private communication device versus what's on a work email account or a work communication device. If you are looking at this, or if you're considering that you may have issues with this, it's an area to take legal advice and to make sure that you're not infringing the employee's privacy rights. Finally, the case of British Airways and Pinot, which relates to a less favourable treatment claim on the basis that Ms Pinot was a part-time worker. She was working more than 50% of her time, but was only being paid 50% of salary for the work that she was undertaking. And what was held is that that is actually less favourable treatment on the grounds of her being part-time, is actually she should have had 3.5% more pay. And the decision was that effectively her pay should be increased to remove that less favourable treatment. That's everything from me this month. As always, if you have any questions, please do let us know, and I'll be back in November. Thank you.